So I'm going to cover the POA and Condo Act again one more time because I've really had a lot of questions and calls the last week about POA and condo documents and when can they void and do they have to tell why they're voiding, etc. So I want to share with you, and this is NVAR form, okay, K1390. NVAR form K1390. You can download it from NVAR. What happened with our contract is they pulled out of the sales contract anything that was an explanation of the law that's not required to be in the contract. So the POA and condo paragraph went from a page and a half each to just a half a page for each one. And the reason they did that is a lot of the stuff was just a statement of what was in the act, but people thought that since it was in the contract, you could take a pen and you could just cross it out and it's no longer applicable. And you can't change statute by doing that. So they pulled all that out. They moved it to this form. I highly recommend that when you write a contract for any buyer or any buyer, okay, that you also use this form and have them initial it or sign it and keep it in your packet that you've gone over all this. I also go over this with all sellers so they know what our law says. So it's called Understanding Your Rights under the Virginia Condominium Act, Property Owners Association Act, okay? And it talks about the property is in an association. Well, if it is, then the seller has to order the documents. And these are the items that a resale certificate must contain, including a mandatory letter that has to be attached summarizing what you need to look for, okay? So there are currently 20 items that need to be, this has 19, but the 20th would be the cover sheet, okay, that's required, that should be in a complete packet. So when your buyer gets the packet or you receive the packet, you can start making sure everything's in there. If it's not, point it out to the buyer. And the reason I say point it out to the buyer is if your buyer receives an incomplete packet, it doesn't have all 19 items plus the cover sheet, okay? Their 3 days start with whatever they receive. They could receive one page of it and it starts. Then they have to make their decision, do I want to void my contract or do I want to take the chance? Okay. Now, I'm not going to read each one of these to you, but I went to a condo association meeting in Penderbrook where I live the other night, and they were talking about all these fees and everything. And I said, well, when's the last time that you have visited our reserves and made adjustments? And, everybody was shocked when I asked the question because by law, it has to be adjusted every 5 years. So if I'm buying in a condo project, one of the things I want to know is when's the last time you visited all these figures to make sure there's enough money at today's cost to cover the repairs to all the buildings, parking lots, etc. Because I don't want to be faced with a large fee, an assessment to bring these costs up. And our condo project's a little old. I mean, I looked at all the reserves and I felt comfortable. We had enough money to do it. But the party that's now managing the condo project said, that's a good question. We have the engineering firms already giving us the figures and everything, and we are getting ready to come out with the new one. And she reassured everybody that our fees are in pretty good shape. But that's one of the questions that I want to know if I'm a buyer of a property. And one of the things I'm going to point out to them as a buyer's agent to think about. So it has to have a statement of expenditure of funds approved, okay, that require an assessment in addition to the regular assessment during the current or immediately succeeding fiscal year, so that I can feel comfortable I'm not facing anything. Now, my condo project in Florida, we just had a $2,000 assessment per unit because they had to bring it when the county came in. They found additional concrete work that had to be fixed, and there was not enough money. We had enough money to cover the initial, but everybody had to pay a special assessment. So you need to know what you're facing when you come in. Okay, so this is the current reserve study. Okay, and the status of the reserves, but it doesn't say 5 years. That's in our statute. So you'd have to know that it has to be adjusted every 5 years. Okay. Your current budget, you'd like to know how much is being spent and on what. Any pending actions or unpaid judgments okay. Now, we discussed in legal updates, one of the new laws for an owner of a single family home or any resale actually, that if you have a lis pendens, a lawsuit against your particular unit, then there's a one-page disclosure form that must now be used and given to the purchaser so they know this lawsuit is pending against your property. Now, when it comes to the condo and POA, that would show up in these documents. So any pending actions or unpaid judgments, etc. Okay. Also, the coverage, what insurance coverage you have, okay, and what it covers, because the lender is going to want that, and they may require you to have additional coverage if it's not enough there. Okay, a statement that any improvements or alterations made are not in violation of the condominium instruments. I've dealt with a couple questions about that recently. Okay. A copy of the current bylaws, statement whether any portion is located in a POA. So in Penderbrook, I'm in a POA in a condo, and I had to receive both sets of documents. Now, the interesting thing in Virginia, I got this question this week. The purchaser received a POA but hadn't received a condo. And in between the time of receiving the POA and condo, they found out that they were misquoted on some other stuff, and they no longer wanted the property. Do they still have the right to void their contract? Yes. The 36 or 3 days to void your contract starts after you receive the condominium or the POA, if there are two acts, two associations covering your property. Okay, so any pending or architectural violations, you should receive the association minutes for the last 6 months. Okay, that they filed, and this is very important. So you can check this yourself by going to CIC, but have they filed their report, okay, for the last year? Because if they haven't, then they can't enforce their rules, basically. So it's important to know that they have filed that. And is there restriction on the number of people that can occupy a dwelling? Now, it can't be in violation of fair housing, but they can restrict occupancy in flying the US flag, solar. Okay, so You have to get that form that's required by the statute. And the POA Act, basically the same, excuse me, as the condo. Now, this used to be included in our contract. And remember, the only thing in our contract now, and I'll bring that up in a few minutes, the mandatory language required by statute is all that's left in our contract. So here's what it says. Now read these words with me. The resale certificate shall be current as of the date specified therein. Did that say it had to be the last, within the last 30 days? No, it could be a year old, as long as they were current as of the date on that document. So the buyer does have the right to request an update, okay? And who has to pay for it? They do, okay? And how many days does the association's representative have to get them that new packet? 10 days. But their time to void the contract started when they received the old packet. And they only had 3 days. So basically, they won't have a right to void the contract on whatever shows up in that updated package they requested. Okay. So it says it does not extend the buyer's right of cancellation when you get that packet. So unless you could get it within that 3 days, then it's just for your information purposes. Now, the buyer's right of cancellation begins upon seller delivery of what they call a resale certificate in a condo, okay? Even including a packet that is not in conformity with the provisions of the POA Act, okay? So if I send you a packet that has 14 of the 19 items, your time has started. The packet's not in conformity with what should be there, but your time has started, purchaser. Okay. So time you receive a complete packet or any part of a packet, or you could receive a notice that there won't be a resale certificate available. If you receive any of those three, your time has started. Now, we had an amendment to our condo POA Act. The right of cancellation could be extended, okay, by ratifying extension review period for condominium resale or association packet or other addendum, but it can only be extended for up to an additional 4 days. Can't be extended past that, okay? And the time period can't be shortened even by agreement. Now, the only way that a buyer can waive the receipt of the package, even if you wrote it into the sales contract, that they have the right, I mean, that they waive the receipt of the documents, they can't waive them in writing, okay? So the only way that you can waive the receipt, okay, is if you did not cancel prior to settlement. So you've never delivered the documents to me. I go to settlement. I waived them. I can't come back against anybody. I can't say since I didn't receive them, I don't have to follow them. It's not the way it works. So if you have not received the documents prior to settlement and you settle, then you waived it and you're bound by everything in those documents.
Larry, can I have a question?
Sure, certainly.
Okay, you're saying that the package come to me incomplete.
Uh-huh.
And my time is kicking, and is the 3 days I have to cancel. But you said I could extend it for 4 days. And the rest of the document is gonna came to me in 10 days. And you're saying that I cannot cancel the contract because I don't have the complete document, but my
No.
client wants to read them or it wants to get out of the contract. What can I do?
No, they have the right to cancel after they receive anything. So
But
here's
you
what,
said 10 days. You said 10 days.
well,
The
no,
rest of them
no,
become 10 days.
no. Let's go back and make sure you understand what the 10 days is about.
Okay,
So if my buyer receives an incomplete packet, okay? They receive an incomplete packet. They have the right, if they want, to order an update package, okay? They can order an update to the package. And by statute, the association has up to 10 days to give them that new update. But that does not give them the right to what? To void, okay? They have to void within the 3-day period of when they received anything. Okay. So
okay,
it says right here, if your buyer, okay, if your buyer receives the package and it's a year old, they can request an update, right? And they can pay for it. And the association has 10 days to deliver that to them. However, the fact that you requested an updated packet does not extend your right of cancellation. Your buyer has to either decide with what they've already received, do I want to void my contract? Okay. Or do I want to go forward with it no
I
matter
see.
what?
Thank you.
Okay. Now, down here, you will see that the buyer may cancel the contract within 3 days or up to 7. So we can add 4 days if the seller agrees and signs an addendum. Okay. So you can take that 3 days to 7 days, but that's still not going to give you enough time to get the updated package from the POA or condo. So it's effort and futility, right?
Larry, may I ask you a question, please?
Certainly. That's what this is for.
Okay, just to clarify the rights of the buyer to cancel when they receive the first package, you say this package can be a year old. What if they order an update and the information on the update is totally different than what they received? They still cannot cancel?
Nope, cannot cancel.
Man, this is going to be challenged in court big time.
No, this has been the law for about 15 years.
But
Let me tell you why it changed. Okay. Several reasons. A seller can only deliver to the buyer what they have. Okay. And so second, we had a buyer agent years ago figure out how to play the system because these used to have to be current within 30 days of settlement. And that's what our statute said, right? And then this buyer agent went out and would take and find different properties and different associations. And they would ask for the seller, and the seller had to supply the update. Under the old law, seller had to supply the update and pay for it, and the purchaser still had 3 days to void the contract. So the buyer agent timed it so that the documents were more than 30 days old before they would get to settlement, and they requested the update from the seller. And then they went back to each of these 3 sellers that were under contract with their buyer, and they said, okay, sellers, how much will you give my buyer to not cancel your contract because of these updated documents? And they played one owner against another to see how much more money and things they could get out of the seller. Was that fair?
No, absolutely not. I
No.
mean, trying
And-
to
and-
abuse
and
the
so-
law. I
and
mean,
so-
you render to change the law or lose
So-
that right.
So one of the people they did this to was one of our state representatives, one of the politicians at the state of Virginia. So what happened the very next year to our law? The law changed and said, buyers, you have the right to order the updates, okay? But you can't cancel your contract because of it unless you can get those updates within the 3 days. And now it's been extended up to 7 if the seller will agree. If you don't like it, don't buy my house. Okay?
Yeah.
If you don't like what you got, void your contract, go buy a different house.
No,
Go
absolutely.
buy a property, it's not in a POA or condo. Come to Mineral.
Yeah, they abuse the sellers, but now it could abuse the buyers.
Well, so there is no happy medium. So that's why I'm making sure that we understand what our statute says. Buyer, this is all we have to give you. Here's the gamble, okay? Do you want to void your contract or do you want to take the chance? Okay, and it is what it is, right? That's why I brought this up in this form. That's why we need to use this form with our what? With our clients to make sure they understand, because it's not in the sales contract anymore. But you as an agent, you're expected to know the what? You're expected to know the law, right? And to be able to explain it to them. Okay. And I'm not taking sides. I'm just making sure that we know what our statute says. Now, it also says shall be the disclosure packet is deemed not to be available if they have not filed the Unit Property Owners Association with either the State Corporation Commission or the CICB. Okay. Now, if a form is, I mean, if it's deemed not available, your purchaser has 3 days from the time it's deemed not available so that they receive a notice saying there will be no report available. Then they have 3 days from that time to void their contract, right? Or if the seller's made a written request for the disclosure packet and the package not received within 14 days, then it's deemed not available and your buyer has 3 days to void. Now, it's 14 days, not from contract date. It's 14 days from the written request for the resale certificate disclosure packet by the seller or their authorized representative. So as a buyer's agent, I stay on top of the other side to find out exactly when they what ordered. So we make sure we know when the 14 days are up. Now, a written notice is that the packet is not available, starts the time period. So here's the time period. Within 3 days. So what if you have the condo documents in your hand right now as the listing agent and a buyer is going to write a contract? Those documents literally could be handed to that buyer then, right up front. So we don't have to wait to order them in 14 days and whatever to find out if we're going to have a contract. So if they're given to them after the date of contract, or if on or before the date the buyer signs the contract, they receive the packet or a notice there won't be a packet, the 3 days start. So before you even sign a contract, I can give you the packet and the 3 days start. So think of a new homes project. when do your buyers get the POA condo docs at a new homes project? When does that happen? Anybody?
Could you repeat the question, please?
If you go to a new homes project and your buyer writes a contract.
When
do
they write the contract. When they,
write,
when they,
Yes,
so
they will
so
give, yeah,
when they write the contract, right?
yes,
Yes.
Has the builder signed the contract?
not yet.
no,
No, so they won't sign it. They won't even consider signing it until these 3 days are up.
That's right.
Okay. So could we do that as real estate agents? You know the listing is going to sell, so why don't we get these documents ordered up front? Okay. Or within 3 days, or written addendum up to 7 days, right? Okay. If after application, I'm going to mute everybody again. Hold on, got some background. Okay, so if we get the packet afterwards and it's delivered after signed, then it's the same 3 days or 7 days extended by ratified contract, but that's an addendum, right? Or hand delivered, etc. Or if these are going to be mailed, if they're going to be mailed to someone, 6 days or up to 10 if we have that additional 4, okay, after the postmark date on the certificate disclosure packet. So they could be mailed, hand delivered, okay, hand delivered, electronic, commercial overnight service, 3 days. If mailed by US Post Office, 6 days after postmark. So we're basically going to do return receipt requested on that one. But this is the one that really causes people to scratch their head. At any time, prior to settlement, if you haven't given me this notice they were talking about that the packet would not be available, or you haven't given me the certificate, the resale package, up until the time I receive the package or a notice that there won't be a package, I can void my contract without penalty. What did that just say? Well, I wrote a contract today. It was accepted by the owner. They order the documents, but I get cold feet 2 days later. Do I have to wait to receive the packet before I
no,
can join my contract? No,
No.
I have the absolute right anytime prior to you giving me the packet or you give me that written notice there won't be a packet. Anytime. Do I have to give a reason?
So
No.
do I have to
No.
get out of the contract with the condo document?
The law says I have the right to void my contract even if I haven't received the documents yet. I don't have to wait, and I don't have to tell you why. I just don't want the property.
So in
And
the
I've heard listing agents say, but we haven't delivered the documents yet. They don't have the right to void. Yes, they do. Well, show it to me in the contract. I can't, but I can show it to you in the what? Statute, the law. Okay. It used to be in the contract, and agents used to cross that out and initial it, thinking they did away with law. You can't do away with law that way.
Larry, when you
Yes.
are sending a notice, what was your reason that you are?
You don't have to give a reason.
I see.
It's automatic right.
So what you send it to the listing agent, you send in a release and notice, right?
You send a notice to void and a release. And when they call and say, why, we haven't even delivered the documents, because they just changed their mind, they don't want it.
I see.
Okay. Now it talks about notice of cancellation. How do you do it? hand delivery, US mail, electronic, overnight delivery, okay? But your buyer has the burden to demonstrate delivery of the notice of cancellation. So I'm sending it to everybody, okay? Any questions about that? This is an excellent form. You should be using it with every buyer in a POA or condo, okay? And have them sign it and date it. I do the same thing with the seller so they know the statute. I want to bring up something else here. So please, any questions about that? Because I keep getting it over and over and over. Well, they haven't received a document yet. You know, do they have to give a reason? Or, you know, had one where the lender literally had forgotten the to add in the POA the POA fee, and it's a substantial fee, right? And the person didn't want the property anymore because how high the payment would be. And they hadn't received the documents. Don't have to receive them. Void it, move on. Okay. Now, this is from DPOR's website. DPOR, Department of Professional Occupational Regulation. You can find these forms. Okay. And it talks, this is the disclosure packet notice. This has to be attached to the POA and condo documents that your people receive. This is a review for them, okay? It talks about, excuse me. It talks about the assessments. They're mandatory. It's not an option that you're going to pay them, okay? I'm dumbfounded by a number of people to find out you have to pay POA or condo docs. Fees. Also, there's governing documents. It tells you what you can and cannot do with in the condo and in your property. Okay. Limitations. Look, you better check and see if you can rent that unit. Whether or not you can have your boat or your motorcycle or your pickup truck. Can you have pets? Okay. Can you operate a business? Are there architectural restrictions that you want to do something to your property and you're not going to be able to? Okay. So this is a review of the things, and our statute requires this so that they can flip through their documents as to what they should be looking for. And it covers, once again, all the things in our disclosure form. So you can use either one you want. Okay. Now, these are the fees. Now, download this from your DPOR site. Okay. Where I got it from. They can charge $117.37, right? To give you that inspection report. Why is it an odd number? Because it adjusts to the consumer price index, right? The maximum they can charge for the preparation and delivery in paper form, 2 copies, okay, $176.05 or $146.71 for electronic. And yes, I can request my documents in paper. And even though they say they don't deliver them that way, our statute says if Larry goes to their management company and is standing in front of them and requests these documents, they have to give them to me in writing. Okay. You want an additional copy? It's $29.34. They can only charge the actual cost of delivery. They can charge a post-closing fee of $58.69. And they can charge a pre-settlement update to the package. That's what the attorney will probably ask for, $58.69. And if they have to come out and do a second inspection of the property to make sure that a violation was corrected, they can charge another $117.37. Okay, and this next time this will be adjusted is next year. The CPI will be adjusted once every 5 years, so you can be guaranteed these fees will go up. And that's the only fees they can charge. Okay, it's written into our statute. And it's the same for condo and POA. That's professionally managed. Now, if it's non-professionally managed, mom and pop, the association's doing it themselves, they can only charge 10 cents per page, a maximum of $100. They can charge $50 to expedite, $25 for an additional hard copy. So that's if it's managed in-house. Okay. So any questions about those?
Yes, I have a question.
Okay.
What if they find a door, I mean, the homeowners association did the inspection and find the architectural mistake there or fault in there. They had the wrong door or the wrong color of the door. Then you request the owner to correct that problem. That is found by the homeowners association and is in the report. Then the client can cancel if they, the buyer can cancel if the seller doesn't want to correct the problem.
If you can prove that that would be, let me see if I can get back up here. I don't know why I lost you guys. Our sales contract, okay?
I mean, it's not a deficiency, but it is a breaking rule of the homeowners association.
No, I understand. I want to bring up our sales contract here for a second. All right, and because it's a good question. Let me find it here. We bring up our sales contract. So here's what paragraph 20 of our sales contract says. Okay. Seller will pay any special assessments, okay, and will comply with all orders and notices of violations of any county or local authority, condo unit owners association, homeowners or POA actions in any court account thereof as of the affecting the property on the settlement date. Okay, so the seller has to fix that. Now, what we have to decide, would that be a default on part of the seller? I'm not sure that constitutes a default. Okay, at this point, they would need to talk to an attorney. Okay, our sales contract says anything that is not satisfied, any term not satisfied by possession date, okay, will survive settlement. So my opinion, just because it had the wrong color door or that type of stuff, would not give the purchaser the right to void the contract. Okay, it would give them the right to sue afterwards, but I wouldn't consider that a material breach. So to the heart of the contract. Now, if it was, say they put an addition on that property without, and it's a violation. That would be different. That'd be pretty major, right? So at some point, they have to decide, do I want to get an attorney and fight this, or am I willing to go back after settlement to enforce this violation of the contract?
Well, that's what I
So
was
it's not,
saying about
it's,
the update documents, because if the update documents reveal something like this, which the first documents didn't, then the buyer still has to buy the property and end with the trouble.
yeah, no, I understand. I feel your pain, but it, you know, it is what it is. They have to either decide, am I willing to gamble buying this property or not? Okay, and so I can understand the other side of this is, how can we hold a seller hostage because they can't get what your buyer wants from the association? Okay, so they had to draw a line in the sand, and that's what they have done, right? That's
Yeah,
what
the
they-
buyer wants to comply. That's really what the buyer wants.
Yeah, yeah. I understand. Okay, but it's a gamble they're going to take. So, you know, the first time I've ever lived in a property that has an homeowners association is now in Pinderbrook. But I just said, okay, this is just a convenience thing for me. It's not really going to be where I live. But I've never owned a property on a POA or condo. I didn't want anybody tell me what I could do and couldn't do. I'm a baby boomer. I'm from that generation where we hated rules. Okay, and I still hate rules. I hate somebody tell me what I can and cannot do. But as a member of society, there's certain things I have to do. Right now, I want to also share with you here 55.1 1800. This is your POA condo law, title 55.1, chapter 18. So I would suggest that you Google title 55.1, chapter 18, and it will bring up the entire condo POA Act. And as you can see, when I gave mine to download, you can see all my notes and highlights because I visit this quite often. And I use different colors for different things. To me, anything in green is a number, so I don't know if we can get this to you the way that I've marked it up. Maybe if you shoot us an email, maybe we can, download this and send to you. Okay. So it talks about, all the things we just talked about, the charges, right? So 18, 10, and 11, fees for packets, right? Rental lots, okay? Who has to supply the documents and the items that have to be in a complete packet, and the right of cancellation, okay? The right of cancellation. I want to share one other thing with you here today, because you can read through the statute as well as I can, okay? And let me find it here for you. It's 1814 I want. Looking for my exceptions here. It's the fees. So here's the exceptions when you don't have to use these documents, okay? And there's exceptions to when the documents are due. If it's by gift, so if I decide to give one of my properties to one of my kids, then there's no packet, okay? Pursuant to a court order, okay? Disposition of a lot by foreclosure. My property's foreclosed on, I don't have to supply a document. If I send the keys back to the lender and they accept them, no documents. However, at an auction, so the property's been foreclosed on and there's going to be an auction, then the documents are still required to be given to the purchaser. And this is how it's done. where the association disclosure packet is made available as part of the auction package for prospective purchasers. So you know those documents are going to be old, but if they're on that website, if they're on the website of the auction company, then they have been delivered. Okay. But this one here is interesting. A disposition of a lot to a person who is not acquiring the lot for his own residence. So if you have an investor buying the property, they can waive the receipt of the documents legally. Okay. As long as it's not going to be occupied as their own residence, unless requested by such person or entity. So even though there's a cutout for investors, when we check box 8 or 9, then they're requesting to receive the what? The documents. Okay. So if they don't want the documents, and there's a statement in the contract of sale, the purchaser's not acquiring the lot for the purpose and conclusive may be relied upon by the seller of the lot. So the way I would interpret that, if it said that this is the purchaser's gonna be a non-owner occupant, and you don't check in 8 or 9, basically they couldn't void their contract because they hadn't received a document. If they did check box 8 and paragraph 8 or 9, then they still have the right to void. So the best avenue is, seller, we're going to have to order the documents for no matter who the purchaser is. Okay. So there's a lot of good stuff in here in the law, and there's 37 sections of it, I believe, that you should be actually downloading and reading through so that you can discuss this properly with your client. But at a minimum, use that form created by NVAR with every buyer and seller. Okay. Any questions about anything that we've discussed?
Larry.
Yes.
Okay.
You said if it's 9 and 8 and 9 is not checked, usually when the contract is filled out, we fill everything out. So if we are check it out, then we need to get the report.
If it's going to be an owner occupied property, the report is mandatory no matter what, whether the box is checked or not. If it's an investor buying a property, technically they could waive the receipt if they put a clause in their contract that they are, not buying the property for personal occupancy. But most investors still want to see the documents. So when you check 8 or 9, whether it's an investor or not, the documents have to be delivered.
The second question, your contract has 13 pages, and mine, I look at it, it has 11. So this is the
Well,
11.
oh no, that I just pulled up any one that I could find. The newest one that says the same thing, but it's, I didn't have the newest one. So the newest one is 11 pages because they pulled all that other stuff out. For argument's sake, I was just pulling up any one that I could find. I
The
didn't pull up.
document you showed, is there any way you could email it to everyone? And you said we have to request it, and just give it to Jocelyn to send it to us?
Well, we don't know who you are unless you send us an email, because I don't think they record from this would know who, where to send it.
So I just have to send that to you and ask you for the information?
Yeah, send a request and we'll
Thank you.
see if we can copy this stuff and send it to you.
No problem. Thank you so much.
Okay. Somebody else had a question?
Yes, Larry.
Yes.
Okay, let's
Sorry.
see. I've got Nassar first, I think it says here. Go
Yeah,
ahead.
thank you very much. Larry, do we have access to the video of this, to record of this presentation? Because I reached to the middle of the present to this lessons.
Nestor downloads all this to a YouTube channel for Fairfax Realty.
All right.
So all my previous sessions plus this one will be on that YouTube channel.
All right. Thank you much. Thanks.
Okay.
Yep.
Okay. Next. somebody else had a question.
Okay, yes, I have a question, Larry. Can
Okay,
you
Sandra.
can you revisit in the contract where it says that any violations will survive the contract, any HOA violations will survive the contract, and expound on your interpretation of that?
Let me see if I can find the latest contract here. Let's
And it
see.
doesn't have to be the latest, because like you said, the terms are still the same.
I still want to find the latest one because it confuses people here. Let me see what's under this one here. Okay. Contracts package 2022. Open. Okay. Let me see how I can increase this so you can see it. Okay, paragraph 32 of your contract. Okay, it says the provisions not satisfied at settlement will survive the delivery of the deed and will not be merged therein. Okay, so anything that either party was supposed to do and they didn't, if we settle, then we still have the right to go back under paragraph 25 that says if a party breaches the contract, okay, then I have the right to get a counsel to enforce my rights here under. So since you didn't do what you were supposed to, and this all survives settlement, I could go back afterwards, get an attorney and sue you for what you did not do. And if I win, you have to pay all my attorney fees and legal costs. If you win, then I have to pay all yours. Okay. But it does survive. And in the old days, okay, in the old days, settlement was it. If we didn't have it taken care of, contract merged into settlement, it was over. But now, not settled the settlement, survive the delivery of the deed.
Larry, that's what the statute of limitations, right?
I'm sorry, let me get rid of this back to close. Okay, ask that question again.
That is within the statute of limitations.
Well, yeah, 7 years. I mean, if after 7 years, you're pretty hard, you should do it immediately, but because look, there's challenges now, and you've got people that can't get supplies. You can't get this and that. Now the good news about the market slowing down, builders are starting to back off on not building houses because they can see the handwriting on the wall. So there'll be a whole lot more people to fix stuff. So we'll be able to get people to fix stuff, but it's a challenge to get stuff done by settlement. Okay. So, got to use some common sense here too. Okay.
Good
Very
information.
good.
Thank you, Larry.
So next Monday, I actually have a doctor's appointment. So I don't think we will be doing a session next Monday. Probably pick up the Monday after. I've got to have a small surgery and I got to meet the surgeon next Monday. So I don't think I'll be done in time enough to meet. So we'll just pick it up week after. And remember, if you have any questions, shoot them to me in my email, brokerlarry1@fairfaxrealty.com, and I'll address it in these sessions for everybody.
Larry,
I have a quick question, please.
Okay.
The July TE training we had, it's not showing up in DPOL yet.
The July training is not showing up in
The
default.
16-hour training.
Well,
Continue.
shoot me your information and I'll check with the board why it's not.
Thank you.
Shoot me an email with your name and your license number, and I'll find out for you why.
Thank you.
Okay.
Well,
Larry,
my
can I
renewal is February 2023 anyway, so I just did that.
No,
in
no,
advance.
I mean, if it's not there, I want to take care of it.
Thank you.
Okay.
Thank you.
Larry, can I get your opinion about the market? Just 5 minutes, 2 minutes
Opinion about what?
on market today. on
Market?
real estate.
Well, market's still good. It's just more of a normal market. Now we're getting back to where agents are going to actually have to work again. You know? So, I still think we're going to see 8% interest rates, as I've been saying all along, probably within 30 days. And there's a lot less qualified buyers out there that can afford in the price range. So, well, houses still sell? Absolutely. Are you going to have 15 contracts on a house the day you put it on? No. So I'm preparing sellers now. You could be 2 to 3 weeks getting your home sold, which is normal. And don't expect this ridiculous thing that we went through. And it's going to be that way for probably at least 2 years, in my opinion. So we're in a more balanced marketplace now, which is probably good for everybody.
So
Do you think
Larry,
interest rate gonna go higher?
Do interest rates going to, absolutely interest rates are going to go higher. Yeah.
but what is the interest now? I'm not updated with it.
Interest, I think, is 6.6 or something like that. So it'll be
Mhm.
8. It'll be 8. I've been telling everybody, remember, for the last 2 years, I kept telling everybody about this time we'd be 8% interest rates. And, I'm sticking by it.
Yeah.
I think I said when, 2 years ago, it'd be November of this year. And I think I'm pretty much right on.
Totally agree.
Yeah. So, I mean, look, this is normal. This is not abnormal. Abnormal was the fact that we had 3% interest rates. Over time, the average interest rate over time has been 7.7%, and we never had 3s. Okay. So, just got to tell everybody we're getting back to normal life now. Everything's going up, right?
So Larry, do you know when you're gonna host another like 16 hours education training for us to take class?
We're gonna do one next month. I just haven't set the date yet.
Okay, perfect. Thanks.
So a notice will go out. Okay. Last time we only had one person signed up, so I decided I wasn't going to do it for one person. But we will do it again in October.
Okay, perfect. Thanks.
Okay. Good. Well, everybody, thank you for joining me. And I've got to run. I've got a 12:30 appointment. I will catch up with everybody in 2 weeks, and don't hesitate to contact me if you need me.
Thank you, Larry.
Thank you, Larry.